Good. My name is Professor Sandra Liebenberg. I hold a chair in human rights law at the University of Stellenbosch, law faculty in South Africa. In addition to teaching human rights law and supervising postgraduate students, I coordinate a project on socio-economic rights and administrative justice at the law faculty.
Thank you very much. May I ask you how you perceive the relationship between the economic crisis and human rights protection?
I think it is very important for us to realize that conditions of economic and crisis have profound implications for human rights, not just typically economic, social and cultural rights, which arise when many welfare and social programs are dismantled or scaled back as a result of an economic crisis, but also many civil and political rights, because the two sets of rights are very much interdependent. So often what happens is when a housing program is scaled back, housing allowances and so forth, people go hungry, they go without fuel, they can't participate fully in society. And I think it's also important to be aware that globally it is often the most poor and marginalized that bear the brunt of economic crisis, usually not the bankers and the financiers and the politicians who've been responsible, but the disabled, single women, children, and so forth.
Thank you. The South African Constitution includes the protection of economic and social rights, and you have published extensively on all those questions. And I wonder how effective this system has been.
Yes, well, we now have almost 20 years of experience with directly protected economic and social rights in our Bill of Rights. And we have a number of landmark cases which have come before the Constitutional Court, very famous cases dealing with housing, healthcare, social security. I think very many important gains have been made. There's been, for example, in the famous Grootboom case, the court ruled that government has an obligation at least to ensure that there is an emergency housing program. In the Treatment Action Campaign case, that there has to be antiretroviral drugs to prevent mother-to-child transmission of HIV. It's ruled that non-nationals have rights of access to the social security system, and it has created a lot of eviction-related case law. I think where there's been less success is often in protecting the quality of the benefits and the system provided. So we've seen sometimes the court not being willing to pronounce on what is a sufficient quantity of water to sustain basic health and life care. But we hope with a new wave of cases concerning the right to education that the court will start looking at the quality of services which are being provided. So I would say that generally the experience has been positive. These rights have created many opportunities and tools for people to hold government accountable, and also private actors like banks and medical aid schemes. And there's been a very vibrant civil society, many human rights NGOs formed to protect these rights and to rally around these provisions in the Constitution. So I think having these directly protected economic and social rights makes people very aware of conditions of poverty and inequality.
Okay, and do you see any way in which the South African experience could be relevant to protecting economic and social rights in the context of austerity measures?
Yes, I do. Of course, I'm not an expert on the European situation, being from South Africa, but I think there are a number of broad lessons that one can draw. In the first place, I think it is very important where constitutional reform processes are underway in European countries to look at the possibility of including directly protected economic and social rights. Secondly, I think in legal training and in the use of lawyers of the existing protections which are in the legal system, whether a right of access to court, non-discrimination provisions, to be more innovative in using those provisions to see whether there is, for example, discrimination against disabled people, women, vulnerable and marginalized groups as a result of austerity measures, and to start expanding the scope of those protections. That would be on the national level. On the regional level, we have two wonderful instruments, the European Convention on Human Rights and the European Social Charter. I won't speak too much on the latter because you have another expert coming in on that. But the European Court on Human Rights has indicated that it will adopt a dynamic approach to the interpretation of the rights, and many of the rights there, like the right to protection against inhuman and degrading treatment, the right to protection of the home in Article 8, the right to peaceful enjoyment of possessions in Article 1, Protocol 1, have been given a socio-economic dimension. And I think building on that case law to provide protections in the context of austerity could be a very fruitful mechanism. And then turning to the international, the UN level, a very, very significant mechanism which should be explored is the International Covenant on Economic, Social and Cultural Rights. In May 2013, the optional protocol came into force, and thus far a few European countries are members: Finland, Portugal, Spain, Italy, a few others. And this creates a potential, once domestic remedies have been exhausted, to go to the UN Committee on Economic and Social Rights and to complain about the impact of austerity measures on economic, social and cultural rights. And a very concrete example would be the very first case which the committee decided was a case against Spain relating to huge mortgage bond foreclosures where people could no longer afford their mortgage bonds, and the legal system in Spain did not provide for notification of the people concerned and a proper proportionality analysis to see is there an excessive impact on the individuals. And an NGO acting on behalf of a number of people affected in this way brought a complaint to the committee, and the committee found a violation of the right to adequate housing and ordered Spain to change their legal system to ensure that there would be access to court, that there would be notification, and there would be a proper proportionality analysis. What is also interesting from that case from a South African perspective is how much the committee also relied on some of the key South African case law relating to mortgage bonds, foreclosures and access to housing. And it cited a number of important cases from the South African Constitutional Court.
Thank you very much, Professor Liebenberg.
It's my pleasure.